When national interests clash, as they invariably do, sovereign states have several options for resolving their differences, including the use of military force. One might scoff at the possibility that disagreements about greenhouse gases might provoke a war, but the anticipated climate changes are likely to displace large numbers of people and to alter distributions of natural resources. Such disturbances have a history of precipitating armed conflict. Diminishing the likelihood of armed conflict provides yet another reason for mitigating global climate change. At the close of World War II, the major world powers established the United Nations, or UN, and the International Court of Justice to save succeeding generations from the scourge of war. The International Court in The Hague, Netherlands, relies on 4 sources of law to resolve differences between states peacefully. Number 1. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. These are treaties, agreements, and other legal instruments to which contesting states are signatories. Number 2. International customs, as evidence of a general practice accepted as law. Customary international laws are widely established norms that sovereign states follow, not out of habit or expediency, but because the states consider them binding legal obligations. Number 3. General principles of law recognized by civilized nations. These are beliefs common to mature legal systems. Number 4. Judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for determination of rules of law. These are determinations of law by the courts of member nations, such as decisions of the United States Supreme Court or writings of publicists, experts in public international law. The following examines each of these sources with regard to environmental issues. An international legal instrument is a document that binds the participating sovereign states to behave in a specified manner. The International Court of Justice and most states do not distinguish between the terms treaty and agreement. This video segment will refer to all legal instruments as treaties. The term convention signifies a formal multilateral treaty negotiated under the auspices of an international organization and with a large number of participants. A convention usually outlines broad objectives that enjoy widespread support without providing details that may be more contentious. A protocol is the next step, a treaty that specifies substantive obligations to implement the broad objectives of a previous convention. For example, the UN Framework Convention on Climate Change established procedures for developing limits to greenhouse gas emissions, and the subsequent Kyoto Protocol contained the specific provisions and regulations about greenhouse gas emissions as discussed in the following video segment. The 2-step process of convention and protocol seems to simplify and accelerate treaty making.